Hello, everyone. This is Chris Cervalera with TAG Alliances. Thank you for joining us on a special webinar talking about the tariff situation going on now in the global economy. Really excited. This is normally, we don't usually do webinars, promote them, and then 2 weeks later have the webinar, but there is a sense of urgency, and we're really excited to promote this topic and allow members to ask questions. We'll get to Sue and John, our presenters, in just a minute, but right now a few quick housekeeping items. Want to announce and welcome a couple new member firms. We've been very active on the recruiting front. Actually, in the past 6 months, the first 6 months of the year, we have brought on 11 new TAG Law, TAG, and TAG SP firms. The four most recent additions are on your screen. We have Seum Law Firm in Korea as our new TAG Law firm. We have Varon Wardwell as our new TAG Law member in Idaho. We have Wooin Accounting Firm in Korea. So we brought on a TAG Law firm and a TAG firm in the same jurisdiction, and it was very exciting. We had our orientation call with both of the firms at the same time a couple evenings ago, and it was great to tell them a little bit more about their membership. And we're also excited to welcome DHC Abogados in Peru as our new TAG Law member there. So if you see these firms on our website, feel free to send them a little note and welcome them to the TAG Alliances. We also have been growing internally. We have a couple new additions to our team here at the TAG Alliances. On your screen, you see Fernanda Musi, who's our Manager of Global Member Services. We have Haley Bacchus, who is with us here actually in St. Petersburg. She's the one controlling the slides as our new Marketing and Communications Specialist. And we also have Carmen Eisenstadt, our new Event Experience Specialist. So you see their emails on their screen. If you have any questions relating to their areas of the membership, please feel free to reach out to them. And also, we want to announce our Atlanta conference, which will be the Fall International Conference taking place in October this year. Very excited. The theme is leadership. We have some great topics and some great sessions. And also, we'll be continuing the discussion that we're starting today, talking about tariffs and trade. The final day of the conference, we will have a panel session on that as well, because as we've seen, things can change rapidly in this area. And I'm sure there'll be plenty to talk about in October in Atlanta on the trade front. So we want to remind you to register before September 14th so you can take advantage of the early bird deadline, and we hope to see you in Atlanta. We're going to get started and introduce our presenters. Sue and John, can you hear me?
Yes.
Yes.
Great. Well, thank you for being with us. I've created, we have some slides with your contact information, but I'll just briefly introduce both of you. Both of you are very active in the international trade world. John Hove is a partner at Scopelitis, and they are a TAG SP member. Their law firm is one of the national leaders in transportation and logistics law. John is an alumni of TAG Law, was also a partner at one of our TAG Law firms before going in-house, and also then making his way back to the private law practice at Scopelitis. We're glad he's a very loyal member and is one of the impetuses for this webinar and our discussion on trade. Susan Cohen-Ross is a partner at Mitchell Silverberg & Knupp in Los Angeles, our TAG Law member there. She is very active on the international trade front, as well as some other interesting regulatory areas such as cybersecurity and information technology. I know we've had a lot of discussions recently about the GDPR and how that might affect firms and clients in the United States, a topic that we will hear more about. But we're really excited to have both of you to talk a little bit about what's going on relating to the tariffs. I know there's a lot to keep track of. Sue just sent us her slides this morning because there were some changes yesterday, and she diligently updated her information. But we're really excited to have you here. If any of the attendees would like to ask questions, you could do so via the chat panel on Zoom, and we will send those to our presenters later in the webinar. So Sue and John, feel free to take it away.
Okay, Chris, thank you. This is John Hove. As Chris said, I practice with the Scopelitis Law Firm, and our practice is limited entirely to transportation and logistics matters. And of course, trade tariffs have a huge indirect impact on many of our transportation clients. However, today we're going to talk almost entirely about the direct impact of trade tariffs, and primarily about the trade tariffs that are being levied by the United States on imports into the United States, specifically on steel and aluminum, and potentially on other products, including autos and auto parts. Mostly we're talking about the nuts and bolts of tariffs, the basis upon which they're levied, how they're put in place, where you find tariff details, what that means in terms of potential liabilities, what alternatives you may have as an importer, the kind of response that tariffs may trigger, and that sort of thing. That's the primary purpose of this session today, and I'm sure is what most of you are on the call to hear. To the extent we have time, we will hopefully be able to talk some about the indirect effects of the trade tariffs, including the way they may impact transportation rates and material sourcing. If not, I'm sure we'll cover those things in much more detail at the Atlanta conference. My role today is mostly administrative. I'll moderate the session, keep things rolling, and hopefully field some of the questions and pass them on to Sue. But the real substantive information today is going to be provided by Sue. And as Chris said, she's a partner with Mitchell, Silberberg & Knupp in Los Angeles. And again, as Chris said, she's a really experienced trade lawyer, not just in the area of tariffs, but in all aspects of customs and trade. If I tried to describe her industry experience, I would leave something out, but I'll just say that it extends from fashion to dinosaur eggs to military arms, and leave it at that. And so with that, Sue, I'll turn it over to you.
And it's too bad we don't have a chance, John. Thank you for that introduction to talk about my military, my dinosaur case, but we'll do that at some other point. So what I thought I would do today, and what came out of the discussion that John and Chris and I had, was there's a lot going on having to do with these tariffs. And frankly, for those of us that are trade nerds, we're literally watching it hour by hour and day by day. And there was an announcement yesterday I will talk about as I get into the slides. But what we're going to talk about is hopefully more of a general interest and hopefully more helpful to those of you that are not, as I like to call myself, a trade nerd, in terms of trying to help your clients understand what's going on, understand their options, and take whatever action they may have depending on where they fall in all of this. So there's a lot being said, and John used the term 232. We're also going to talk about 301. These are two different kinds of tariffs that come out of different sets of places in the law. But here's the key slide for today. These are all the tariffs that are currently under discussion. Now, it's important to understand this is in addition to the regular rates of duty. So if I bring something in that already has a 10% rate of duty on it and I fall under the steel case, then I'm now paying 35%. So we have 25% on steel, we have 10% on aluminum. Those numbers are set, and they will only change if there is additional presidential action. The thing that's driving everybody to drink right now, so to speak, is the 301 tariffs. And I'll talk a little bit more about what each of them comes from and what they're intended to do. But just for purposes of teeing this up and trying to make it as easy to understand as possible, there are currently 3 lists having to do with 301 and having to do with China. The first one of which is final, meaning the 25% is being assessed. There's a second list going through the notice and comment process. So the first list is what you're hearing in the general press referred to as the $34 billion worth of product. List 2 or Annex B, depending on where you look for it, is the additional $14 billion worth of goods that the president talked about assessing additional duties on as a form of a penalty on goods originating in China. There's a third list, and this is the one where there was action taken yesterday. This third list is intended to bring the volume or span of the Chinese goods subject to these surcharges to $200 billion. Until about noon yesterday, I would have told you that the number being discussed is 10%. However, United States Trade Representative Lighthizer issued a notice yesterday indicating, could be today, could be tomorrow, that there will be an announcement in the Federal Register, which is, for those of you not familiar with it, where all the official stuff goes and puts the world on notice of what we're doing. And in that Federal Register, the proposal will be to consider not 10, but 25%. Whether there will be a list 4 at this point is conjecture. List 4 would arise because the president has been talking about imposing these additional tariffs or surcharges on up to $500 billion worth of goods. As this is all going on, there is also a 232 investigation having to do with auto parts. It's going through the notice and comment process, and all we know about a potential number is that the president some number of weeks ago tweeted 20%. We just have no idea where that one's going. So let's get into a little bit more detail. As John said, we're going to talk primarily about the import impact, but it's important to keep in mind that this list of countries, which I honestly haven't had a chance to update for about a week, is the list of countries that have filed for retaliation on the 232, so the steel and the aluminum. And then China not only filed on the steel and the aluminum, but also on 301. And to be clear, we also filed under 301 against China. And all of this retaliation, to the extent that it will occur before the World Trade Organization. And that's a whole other discussion that we can have at a different point in time due to time constraints today. But certainly every major trading partner that we have has objected in more ways than one to the steel and the aluminum tariffs. Now, let's start with the 232 tariffs. I don't want to spend a lot of time on this, but it's helpful to understand what it's all about and where it's going. So 232 is a provision in US law that allows the president to impose either tariffs or quotas or both in the event that something has an effect on national security. The law envisions that economic security equates to national security. And whether you buy that argument or not, there's at least a tangential relationship between steel and aluminum and the need for military use of it. What will happen and what did happen is there was an investigation conducted. I'll give you a link later on to where you can find the report. And eventually there was a finding that the glut of steel and aluminum on the market is causing a depression to the steel prices and the aluminum prices in the US. A lot of us have been following that, and the price of steel has gone up 50% in the last year. So clearly the price is going up. Unfortunately, it's making the price of US steel not competitive worldwide. And this goes back to a problem that I'll touch back again on when I get to what's going on with Europe and the recent announcement. So, not wanting to bore you all, there are specific tariff numbers that apply whether it's steel or aluminum. And your clients and customers will know what these numbers are. The equivalent I would suggest to you is filing a tax return. When you import goods, you file what's called an entry. There's a lot of transactional specific information that goes on that declaration, and the tariff numbers are among them. Here's the numbers for steel. And just to be clear, the tariff is international to the 6-digit level set by the World Customs Organization. Now, we've resolved as the US what we're going to do with Argentina, Australia, and Brazil. And you can see here that in these cases, Argentina and Australia for aluminum, and Argentina, Australia, Brazil, and actually South Korea are exempt from the tariffs, the steel and aluminum tariffs, as of June 1. And this, of course, is something that needs to be watched to see whether there'll be any other countries that will be exempted. In the case of these three countries, you can also see that they've been subjected to quotas, which means that there's a total volume that can be imported from each country in a specific context. The next few slides are really for the trade nerds. I included them to the extent that you're going to have discussions with your clients and customers. Really, the important thing to keep in mind is because this comes up in every conversation, there is what is called a de minimis rule. Every country has a rule that says so long as the goods do not exceed X dollar value, you can bring them in very informally. In the US, it's a very high number. It's $800. It does apply to the 232 tariffs. It does apply to the 301 tariffs, meaning if the value of the goods is less than $800, the surcharge or the tariff does not have to be paid. Foreign trade zones are a kind of a warehouse where you can put stuff in without paying duty and bring it back out later. We have a recent ruling from Customs that says you can't bring a larger shipment in and then break it down in a foreign trade zone into shipments that are worth less than $800. That will not be allowed. There's a whole bunch of other stuff here having to do with foreign trade zones and how they can be used. If you have clients that deal in foreign trade zones, this is helpful for them to look at, but it's an education unto itself. So I've included it for that, just that basic informational background. Certainly for those of us that are trade nerds, we're happy to talk to folks that are dealing with this, and they're frankly having a lot of conversations with their customs brokers about this. The key for those of us that are dealing with this, whether it's the casual inquiry or whether it's the more substantive stuff that I get down and dirty on, the key question is, how is the importer identifying the potential risks and liabilities? And this is a question of how you set up what you're following and how you're following it. And I think there's, if Chris left my slide deck intact, there's another slide later that sort of raises the question of just what some of the sources of information are. But if by now the company has not set up ways in which to figure out how it's impacted, whether it's the 232 situation or the 301 situation, they're very late to the party. But that's the first step, figuring out how you're impacted and what you need to know. All right, so for all of us now, the one thing that can be done if you're hit by the 232 tariffs is you can seek an exclusion. And the process is just a little different between 232 and 301. So let's talk about 232 first. So here's the key. The Secretary of Commerce can grant the exclusion, and it looks to whether there is a sufficient and reasonably available amount or of a satisfactory quality or based upon specific national security considerations. Now, one of the things we noticed very quickly when a lot of the exclusion requests were filed, they focused a lot on the increased cost of the goods in the US. And a lot of the steel companies' responses were, well, we can provide it, they just don't want to pay the difference. So you have to be careful how you file these exclusion requests and what you say. So individuals and organizations that are permitted to file are literally individuals and organizations, so companies and individuals. When we get to 301, trade associations are also permitted to file. In the 232 context, it's ask for the exclusion request, anybody can object. And then the organization or the entity within the government that's dealing with these can ask for more information if they want it. In the 301 context, you'll see we have file the request, an opportunity for objection, and then an opportunity for reply. So we'll see how this all turns itself out. The only reason you have two slides here is that the reference to the presidential proclamation is different. But the basic idea is anybody that provides steel or aluminum for construction, manufacturing, or provides either steel or aluminum to users in the US is permitted to file an exclusion request. One of the interesting things that enters into the strategy about how you do this is when you look at the form, it asks where the parent company is located. So they're really looking at whether it's an American company or whether it's a subsidiary of a foreign entity. These are the key points. Not produced in the US in a sufficient quantity, not reasonably available or of a satisfactory quality. This literally gets down into the, what can you get here? What's the differences in the technical specs and so on. One of the questions that comes up frequently is, if we file for an exclusion request, can everybody benefit? And the answer is no. Only the company that files for the exclusion request, which is filed at the product level, will get the benefit. And this is different from 301, where if one product gets excluded, everybody else that brings in that product gets the benefit of the exclusion. So if somebody else filed an exclusion request, and this comes up a lot as well, can another importer file? And the answer is yes. But if you're going to help them file, you want to make sure that you've looked at what's been filed before, Have there been denials or have there been refusals to grant the exclusion? And if so, you want to make sure you're stating different grounds. So whether or not one has been filed, whether or not one has been granted or denied, you can still file on your own. This is more for those of you that want to really get in and look for more detail, here's the links for the aluminum exclusion request that takes you to the form. It gives you information of what to gather on the Microsoft Excel spreadsheet you're going to use. And keep in mind, everything has to be uploaded into regulations.gov, and everything filed in the 232 cases is public. When we get to 301, there's an ability to file confidential information. Basically, they learned, the regulators learned from the 232 process what was really cumbersome and not working well. And so they've changed that around. Here's pretty much the same information, a bit more detail, and this just happens to be the aluminum exclusions. One other key point is these exclusions are only good for 1 year. Scuttlebutt has it that these tariffs may last 3 to 5 years. Nobody really knows at this point. Obviously, the likelihood of that happening will depend on a number of factors beyond the scope of today's discussion. But 1 year, and part of the reason the expectation is that it's only 1 year is it's very difficult, as you all know, to change sourcing. And it takes at least a couple years. So when you're looking at 1 year, a lot of the exclusion requests that are serious talk in terms of two things. One, there isn't enough capacity in the US and the problems inherent in that. Or two, we'd be happy to move to pick a country, but we're going to need 2 or 3 years, and here's the reasons why. So this is a process that's been set up that says, okay, we'll give you year 1 the exclusion, tell us what the changes are in year 2, we'll think about it, and so on. There are some really good bits and pieces of information that have been put up on the web. The agency that's administering the 232 tariffs is called BIS, or it's the Bureau of Industry and Security. It's a different part of the Department of Commerce than would usually deal with import issues. But they've done a good job with all kinds of documents. They're relatively easy to find, and there's some good Q&A information there. Here's the same information relevant to the steel case. Be careful, though, because the docket number or the key number that you insert when you're searching in regulations.gov is very case specific. So the one for steel is different than the one for aluminum. And then again, a 1 year exclusion. And again, here's some more information where you can find really helpful tips. All right, so what happens in the process is you file the exclusion request, you use the form they've got. I think there's a 25-page limit. The first thing that happens is those are being reviewed for completeness. Now, the practicality of that is, and the importance of that is, lots of them are getting rejected because they're not being complete. The other piece of it that's critical is only once it's complete does the exclusion request get posted up on regulations.gov, and that is the critical date. Because however long it takes for the exclusion request to be decided, if it's granted, you can only go retroactively to when your exclusion request was uploaded as a public document on regulations.gov. And it is a public document, and it does remain a public document. Once you've filed your request, as I said, anybody else can file objections. They do have to be specific. They do have to deal with what the product is and why you can provide it and why it's there in reasonable quantities and so on. It can't just be, oh my God, this is the worst thing that's ever happened. Some other details about what needs to go into the objections. One of the things that happens with the 301 process is, as I said, it's request, objection, reply. All right, 301. Just to be clear, steel and aluminum applies to every country. The 301 tariffs only apply to goods that are originating in China. So the key is the country of origin, not the country of exportation. And what that means as a practical matter is if you have goods in China that you can establish were made someplace else, you can still export them from China. And if you have the right documentation, you can still get them in without the 301 tariffs being applied. And again, right now we're only talking about those things on list 1. Okay, so 301 is a different provision of a different trade act, and it allows the government in the US to take the position after an appropriate investigation that one of our trading partners is, as the language of the statute calls, is violating trade agreements or engaging in other unfair trade practices. And at that point, additional import duties can be imposed. And that's the process that we're seeing now. And I'll talk quickly about what some of those things are all about. But as you can see here, the US Trade Representative determines that an act, policy, or practice of a foreign government is unjustifiable and burdens or restricts United States commerce. In other words, it takes unfair advantage of US business. And here's the citation for those of you that wanted about the imposition of duties or other restrictions. As I said earlier, there are 3 lists, and the primary focuses of most of these are aerospace, information technology, communication technology, robotics, and machinery. And that's on the lists on which the US is imposing its tariffs. And again, here's the operative question. Does the client have systems in place to identify the potential risks and liabilities, and then hopefully also to mitigate them? And we'll talk a little bit about the mitigation end of things as well. This is the slide I was referring to earlier. These are the basic 4 places that any importer is going to be looking at. What are the releases from USTR? It was in a press release yesterday that USTR Lighthizer made the point about going from 10 to 25% on list 3. There are presidential proclamations that are published on the White House website, the Federal Register notices, and then a lot of the implementation, the nitty-gritty details, are being published by Customs and Border Protection, which is the primary enforcement agency when it comes to the importation of things. So let's talk a little bit about what we're trying to accomplish here, and then we'll get into a little bit about how 301 is working. So a lot of this has kind of been covered in the general press, and honestly, some of it's been pretty good and some of it's left a lot to be desired. But the primary focus of all of this is China's Made in China 2025 policy, which I'll talk about in a little bit more detail in a moment. But the basic idea is this is where China wants to be in terms of industries in the forefront by 2025. And so the US is attempting to target those products that, in the view of the US government, will benefit China the most. You can find the USTR report at the link I just gave you. Here are the industries that are part of the Made in China 2025. And some of these are not surprising. I mean, you look at biomedicine, robotics, new energy vehicles, of course, is all the solar stuff, next generation IT, and so on. So anybody that's got product that's in one of these industries is going to have a bit of a hurdle, a bit of a higher hurdle, I should say, in trying to get any kind of goods either taken off the list or to seek an exclusion. All right, so list 1 and 2. So you've heard me say a couple times it's list 1, Annex A, list 2, Annex B. It's list 1, 2, and 3, actually, if you got the information off the USTR website. If you got the information from the Federal Register, it's Annex A, B, and C. This part has at least been covered relatively well in the general press. So list 1 is the $34 billion, 818 tariff lines, 25% duty, and this is effective, as everybody knows, as of July 6. List 2 is the one that's currently undergoing the notice and comment or review, 284 tariff lines, 25% proposed, and this is the $16 billion. And then now we get to the $200 billion, it's 6,000 tariff lines, and this will give you sort of in general terms some of the specifics of at least broad categories of product on which the tariffs are being proposed. It's worth keeping in mind as we go through all of this that there are 4 industries that the US has traditionally protected. And when I say protected, that means very high rates of duty, very complex rates of duty, very complex rules about what needs to be done with the product for it to be compliant to be imported, and so on. And those 4 industries are steel, auto and auto parts, footwear, wearing apparel, and textiles. And you can make your own judgment on how competitive you think one or all of those industries actually are now. But you'll notice in here that textiles are mentioned, motor vehicle parts are mentioned, the steel and aluminum we've already talked about. Interestingly, not much in the apparel area got hit, and certainly no footwear. Whether those are going to be forced to go on the next list, if there is another list, remains to be seen. All right, so the exclusion process under List 1 or Annex A. First of all, unlike the steel and aluminum tariffs, in the 301 context, all of the requests for exclusion have to be filed no later than October 9, 2018. They are not processing any of them until that date passes and until the next two steps occur, which is for another 14 days from October 9, anybody who wants to object can file an objection. At the end of that 14-day period, there's another 7-day period where anybody can file a reply. So we're going to be out into the end of October before all the comments are in, much less before we get any idea of how these cases are going to come out. Again, for 1 year, but again, the particular exclusion, assuming that it's granted, will apply to all imports of that same product. So not surprisingly, we're saying to our clients, well, how do we describe your product that makes it as unique as possible from anybody else's so that you get the biggest benefit for the effort that you're putting forth? And again, Customs and Border Protection is going to enforce this. So one of the things that you need to think about is what's the best way for the agency to do that. The identification of the product, and this is where we're all helpful to our clients, is in terms of its physical characteristics and other things that distinguish it from other products within the covered 8-digit subheading. So, sorry, that's a term of art. As I said earlier, the first 6 digits are international. They're agreed to, as I said, at the World Customs Organization. Everything from 6 to 10, and it is 10 in the US, but not in every other country, have to do with how you break something down. So for example, if we're talking auto parts, an engine might be one thing, but bearings might be something else, and a carburetor might be another classification. Anything that requires identifying the product by anything that would be considered confidential will not be accepted. You have to be able to provide objective criteria. And frankly, this is 2 reasons. 1, because that's the only way that the folks at USTR are going to be able to deal with this. And 2, Customs can't enforce this in any meaningful way or any reasonable way if they have to start using confidential information. All right. So what we're going to be able to do here is a combination. Remember I said under the 232 context, everything was public and it was just filing for the exclusion request and then for the objections. Here, there is an ability to file. You must file public information, but you may also file business proprietary information. You have to file at what's called the 10-digit level or the full tariff number. And again, you're encouraged to provide information about how to make it as easy as possible for Customs to administer the exclusion. One of the interesting things that's being asked for is the annual quantity and value of the Chinese origin product that the requester purchased in the last 3 years. Not quite sure why they're doing that other than perhaps as a qualifier to help them figure out which ones to deal with first. In other words, is this somebody that's bringing in a large quantity of a particular, large quantity and value of a particular item, or is this just somebody that is bringing in a small quantity? And then trade associations are able and available and authorized to file on behalf of their membership. One of the challenges, of course, as we're having discussions with our clients about this, is that trade associations tend to provide more general comments because, of course, there are often competing interests within the association. But this is a help for those that are small, perhaps, and don't have the wherewithal to file their own comments. But the first question that everybody has to answer is this particular product available only in China or only from China? We have clients whose answer to that is, well, that's the only place I make it. That's not really the question. The question is whether this particular product that you're talking about asking for an exclusion on is currently being made anywhere else, preferably in the US, since the stated purpose of all of these tariffs is to bring manufacturing back to the US. But is it being made someplace else? And more often than not, the answer we're hearing is either no or yes, but I'm so far down the list of those that would be likely to be able to get it that it doesn't matter that it's made someplace else. And those are valid points to make when you're filing the exclusion request. There are a whole bunch of other things that come into play in terms of the exclusion requests, like, does it require tooling? Is there special training that the staff would need? Never mind the usual stuff that goes into figuring out where you could relocate production to. And then, of course, for a lot of industries, one of the questions that comes up is, are there environmental issues that the production process raises? All right, another criteria, one of the things we keep saying to clients is, please try to avoid talking just about the cost element of this. But the cost element of this is a factor, because they do want to know if the tariffs would cause severe economic harm. So this is talking to clients about, if you have to pay this additional 25%, what does that do in terms of the cutting of your workforce? What impact does that have on your profit margin? For a lot of companies, that's pretty serious on its own. But then you have to think about what you can get from your downstream business partners, particularly those who buy your products, and what the impact would be on them. And so in talking about doing these exclusion requests, or frankly, even the comments that are still able to be filed on list 3, excuse me, these are factors to consider. And then, of course, identifying whether you are or are not impacted by the list of industries on Made in China 2025. And then particularly, is your product line one that would or would not have something to do with all of these intellectual property rights issues that are going on with China? And so having patents or trademarks or selling branded goods, private label for somebody else, these are all factors to work in. And not that I'm a big fan of citing statistics, but when you talk about intellectual property rights in China, and just talking about the seizure rate in the US, so as you've heard from both John and Chris, I'm in LA, which means we are typically the first port of call for most of the goods coming in from China. Roughly half the seizures that occur in Los Angeles, having to do with seizures just generally, involve goods from China. And of that 50% of goods from China, something in the vicinity of 80% of them are seized over intellectual property rights infringement. So it is clearly a serious problem, just for everybody. And exactly how it should be handled is, of course, again, another topic for another day. All right, what are the characteristics that make your product unique? Physical characteristics, market niche, technology. So I had a conversation with a client recently who said, well, look, we only make the stuff with old technology in China. We make stuff here in the US and it's all the updated technology. It's all the cutting edge stuff. In any exclusion request you file or any comments you file, this is sort of a little bit of the, can the product be found in the US? If not, what would be involved in ramping up production in the US? What about ramping up production elsewhere? Is the part or product able to be used for national security purposes? So this might be having to do, for example, with critical infrastructure. How it all, I've talked about this one, the impact on China's IP practices, but there are other key Chinese industries. Are the products in that industry? Again, the disproportionate economic harm can be critical for a lot of companies, and in particular for the small and medium-sized businesses and consumers. One of our clients is in an industry where there's a lot of DIY sales. And if their products go up 25%, we've already figured out what that's going to do to their market, but we're really going to try to focus on the downstream impact on the individual guy or gal that's going to go into the local hardware store and try to buy a tool to do whatever it is they're going to fix at home or their vehicle or whatever. So all of that should be included in any filing. A little bit more about the relocating production. For those of us that get involved with our clients on this, the list is obviously much longer, but here's just some key things to think about. Product quality. I sat with a client yesterday talking about they're looking at relocating into India and they can get a good price there, but they can't get the product quality. They can't get the service. How far away is the new facility from where you are? One of the benefits that China has is that geographically, from a shipping route perspective that John can speak to very well, they're typically a pretty direct route. You start going any further west, you go to even Vietnam, goodness, if you go to India, it's really much more of a distance. So if you're looking at a distance question and relocation, how far back do you have to move your supply chain? You can look to bring in from China in a matter of a couple of weeks. If you got to bring in from India, you're looking at maybe a month, maybe 6 weeks. And then some of these other things, additional product costing, tooling, training, all those other things that go into moving production. Here's the information on list 2. Now, on list 2, we're done, meaning the public really can't do anything more. This is really now all about waiting to see what happens. I've been asked multiple times, what do I think is going to happen? I'm sorry, I don't have a crystal ball. The only thing I can say, which is kind of an obvious comment, is given the announcement from yesterday, I think the likelihood of list 2 going into effect is probably greater. And if you didn't hear the announcement, it was the one comment I made earlier about the list 3 going from 10 to 25%. The press coverage around it is all about, well, the Chinese haven't changed their practices, so we need to put more pressure on them. How do you put more pressure on them? You enact list 2. All right, list 3. So the important point here is you'll notice that there's an asterisk right here. And I've done this because the change in dates for the submitting the written comments remains the same, but it's been moved for the request to appear at the hearing, and it's been moved for the rebuttal comments. So clearly one of the things they want to hear about is if it goes from 10 to 25%, what is that impact? But the reason for the asterisk is there's, as I said earlier, going to be another Federal Register announcement. And so we'll need to add that citation when we get it. All right, here's the highlighted is the docket number for regulations.gov. Unfortunately, a lot of the comments that have been filed are things like, you know, I'm a little farmer in Tennessee and what you're doing is going to kill me. And while I don't think any of us are unsympathetic to that, that's not going to get the kind of response that you're looking for without the backup to why it's going to kill you. It's also interesting to keep in mind that when list 1 was published, it was intended to be the complete list. And one of the things that happened with the comments were there were a lot of them who said, well, geez, how about this product? How about that product? How about the other product? And so that's what triggered list 2. What we don't know at this point is whether the same phenomenon will happen with list 3, so that if there is a list 4, it's going to be broader in scope. We'll have to see. Here's the instructions on submitting comments for those of you that want to take a look at it. Again, there's a lot of really good detail on the websites. I want to spend a couple of minutes talking about the 232 case on autos and auto parts. And then I'm going to talk quickly about the current situation or stand down with the EU, and then we'll open it up for questions. So for those of you that haven't seen it, these are the vehicles, so cars, SUVs, vans, and light trucks. These are the vehicles on which this investigation is focused, and automotive parts which are sadly undefined. So we don't really know what the impact is going to be here. We do know when it was announced that the impact was intended to be in particular on German cars. We'll see what happens from here. Again, here, the public hearing has occurred. There's nothing else been published. We have no idea what's really going to happen, especially now that there's a stand down with the EU. But, you know, popular thinking is we're likely to know the results in the next 30 to 60 days. Yeah, 30 to 60 days. So let's talk quickly about the EU-US. I've called it a truce. That's what it really is. It's an agreement to talk. For those of us that are trade nerds, everything that is on this list that you see in front of you is topics that were being discussed when the US and the EU were discussing a free trade agreement, the Transatlantic Partnership. So in the press release that came out after the EU Director General and Mr. Trump met, they talked about all of these factors, and every one of them is certainly an important and a laudable goal. But all they did was agree to talk. And they agreed to talk about each of these issues: zero tariffs, zero non-tariff barriers, zero subsidies on, and notice, non-auto industrial goods, reducing trade barriers, and increasing trade and services. Now, the reduction of barriers has to do with things like the EU has what they call RoHS, which is their chemical protocol that you have to deal with. They have different rules about marking goods. They have higher rates of duty on certain things. So all of that is subject to further discussion and negotiation, and we'll have to see how that all turns out. They want to open up markets for farmers and workers. Well, this now taps in particular with farmers into a lot of local politics, because there's a strong agricultural community in both entities. I'm using that loosely because the EU is not really a country. The one EU concession that came out is the one that's on here, which is that the EU is to import more natural gas. And we're supposed to look at slashing costs and reducing bureaucratic obstacles and so on. Here's the interesting question as you look at this list. So we've settled with Korea because we renegotiated our free trade agreement with Korea. We've agreed to talk with the EU, and we'll assume for purposes of this discussion that leads to some further agreement rather than the imposition of either the steel or aluminum tariffs or any other kinds of tariffs. Where does that leave the Japanese, which are the other major manufacturer overseas of autos and auto parts? And keep in mind, of course, as I'm sure you're all aware, there's a huge effort or a lot of operations in the U.S. South where various foreign car makers have set up U.S. operations. All right, so one of the other things that you see on here is to reform the World Trade Organization. There are a lot of issues about its fairness and its openness and all of that, and we'll see again where that goes. But even if it were to be a process where the EU and the US decided they wanted to go to the WTO to solve these disputes, this is a 3, 4, 5 year process. So we need to find negotiations to resolve these issues in the short term. The other thing that happened is there's going to be an executive working group set up, and it's going to be the closest advisors for both of these individuals. They're going to look for short-term measures to facilitate commercial exchanges and assess existing tariff measures. I think that's government speak for we're going to look at what we can fix in the short term without a whole lot of effort and deal with the other issues in a longer term. Although nothing is said in the press release, the surrounding general press commentary is suggesting, with good reason, I think, that the threatened auto and auto parts tariffs are not going to be imposed so long as these discussions are ongoing. But that is not in the press release that the parties issued, so we'll just have to see what happens. Last couple of minutes on best practices, meaning things that we're recommending and that you may want to recommend and adopt for your clients. First of all, are the classifications correct? And we're going to run out of time for any questions, so I'm going to go through this really quickly. If the classifications aren't, how do you deal with that? And how do you disclose that and do that in a way that's the most beneficial? Obviously, you have to be clear which list your goods are on, and some people are on more than one list. There's a concept called tariff engineering. That is, you can redesign your product, and if you do it correctly, it's a legitimate exercise, so that the end product you bring in falls in a different classification, and hopefully that classification is not on one of the lists. There's a concept called first use, where under the right circumstances, if there's back-to-back sales, so seller sells to middleman, middleman sells to your client, it is possible to declare as the value of the first sale, that is from the supplier to the middleman. Some complications because of the disclosure of the middleman's price, and he may not be willing to do that. And also, of course, bringing in the whole spectrum of trade advisors, because customs brokers can be helpful on classification, freight forwarders certainly can be helpful on freight rates and timing and so on. And then, frankly, this is sophisticated enough that it's really the trade bar that's dealing with a lot of these issues and providing the assistance, although a number of the accounting firms and a number of the brokers have what they call trade advisory groups or consulting groups that are involved with this as well. Considering relocation, I'll skip the reference to the New Importer Task Force in the interest of time. Alternate sourcing, some of these factors we've sort of talked about and touched on a couple of different times. And then when you focus on either the exclusion or the comments, again, it's all about the objective factors rather than really just talking about the pricing. And then one of the factors to ask is, should you even file an exclusion? Is it worth the effort? Is it worth the time? Is the product important enough? And then lastly, I want to mention just quickly, making sure that in the supplier agreements and the purchase orders and so on, that there are provisions that the supplier will provide whatever backup supporting documents are needed, and that there's a reasonable period of time within which they've agreed to do that. And that, of course, anticipates that there will be some kind of a penalty clause for their failure to do so, although the lack of documents may not help you with the agencies. And then the very last thing I want to mention is that because the rates of duty will go up, the amounts of duty that will be collected will go up correspondingly. And that is, we're already seeing that Customs is requiring larger bonds from importers. For those of you not familiar with it, in order to be an importer, you have to have a customs bond. And so if you, the amount of the bond is determined by a combination of the value and the duty. So you can quickly understand that if the duty amount being collected is going up, they're going to want more collateral or more assurances, that is, Customs does, that any of the bills that it issues are going to get paid. And then there's a couple of other things here that really we'll just sort of skip for the interest of time. And John, I'm going to kick it back to you and to Chris so that we can get to any questions we may have.
Thank you, Sue. That was just, oh, yeah, we're unmuted. Sorry. That was a lot. Appreciate definitely your expertise. I'm definitely not a trade expert, but I feel like that distilled things down. John, I'm going to turn things over to you to ask a couple questions. And if there's anyone listening who has questions, you can send them in via the chat panel on the bottom right-hand side of your screen. Just type them and send them to us, and we can tee them up for Sue and John. So John, can you hear me?
Yeah, can you hear me?
Just speak a little bit louder.
All right. Thank you, Sue. That was a lot of information for everybody to digest, and maybe a little bit difficult for people to find a really good question to ask. But I can think of a couple that may be simplistic, but maybe distill a little bit of the things that you covered. And again, these may be a little bit simplistic, but one thing is, we talked a lot about filing comments and filing exclusion requests. So just for those of us who are not really trade nerds, who can file comments and exclusion requests? Is it only importers? Or, there's a lot of talk about, there are nail manufacturers who are going to go out of business because they say they're going to go out of business because of the steel tariffs. Can they file a comment? Can they file an exclusion request?
So so John, sorry, I was hoping that I had been clearer about that, but let me go back over it, because this is a very fundamental question about which there's a huge amount of confusion, even with those that aren't trade nerds. So on the steel tariffs and the aluminum tariffs and the China 301 list 1, all of those are now final, meaning that they're being collected. So if you fall on one of those lists, your relief, to the extent that you have any, comes in filing for an exclusion request, in which you take a lot of the information I sort of tried to highlight and anything else that really applies. And you say, in essence, in filing this information, we should not be subject to these tariffs because, and explain the because, and it becomes about the product and the impact and all of those other things that I was trying to get into at a high level. If you're on the 301 list, either 2 or 3, meaning it's still in the talking stages, then it depends on which list you're on, because on list 2, there's nothing that can be done at this point. On list 3, the comment period is open, and I always mess the date up, but it's, I think it's August 17 is that Friday. And then you're basically taking the same kind of information, but instead of saying my product should be excluded and I should be excluded, you're basically saying the tariff number that applies to my good, here's the good I'm talking about, should not be on the final list because, and then again, what's the impact? What would it do? In the case of the steel manufacturers, they're just basically out of luck. They've got to go for an exclusion, and that's really all they can do. Harley Davidson, you're seeing a different reaction. It's the other one that's been in the press. And there, what they're doing, look, Harley's going to continue to make motorcycles for the U.S. market in the U.S. But they're now, in order to avoid the retaliatory tariffs that are going on in Europe, they're moving production for the motorcycles they're going to sell in Europe to Europe.
Okay. You still there?
Yeah, go ahead.
Okay. So one other question, which I think maybe falls into the category of speculation, but is of interest, I think, to everybody, and this will just be you, maybe based on your background in this over many years, is what kind of criteria do you think will be the most important criteria in judging the U.S. government judging which exclusions to grant or which comments to give the most credence to? What will be the most important matters that they'll consider?
You know, John, that's a very reasonable question. And I'm going to try not to get political here because that doesn't help anybody. The great unknown in all of this is just how serious the US is in considering taking any products off the list. And what I mean by that is, if the purpose of doing this is to ratchet up pressure on China, to get China to change a number of practices, forced technology transfers, such as not enforcing intellectual property rights to the degree we think they should. Some of the other sort of local requirements, like a company in China has to have a certain percentage of Chinese ownership. If the goal is to simply put as much pressure on China as we can to get them to change those and other practices that I haven't mentioned, then I'm not really sure that anything is going to come off. And in fact, if that's ultimately where we're trying to go, this is where list 4 comes in. If we take a step back and expect that at the very least, if the government does this and begins to have a serious impact in certain industries, such that it would put out of work a lot of workers, it would close a lot of companies and so on, then obviously the economic factor is a big one. But in trying to distinguish one product from another in that context, I think it comes back to what's unique about that product. So if we stick with your nail example, John, what's unique about those nails? How are they used or made, or is there a patent involved? Any number of those sort of factors that get mentioned in passing as I was going through could be the deciding factor for a given commodity. Now, I say that understanding also that one of the phenomenon that we saw with the 232 exclusion requests for steel and aluminum was if you filed a request and there was an objection, you basically didn't get your exclusion. It was just denied. So whether that same scenario is going to play itself out here, frankly, on my part, is just pure speculation right now.
Chris, do we have any other questions from the audience?
We don't. I have one. Sue, what are you kind of seeing? And again, this is kind of speculative, but I've watched a lot of news reports and kind of, you have to take things with a grain of salt because of the political tones. But opportunities in other practice areas that are kind of having a ripple effect. Whether it's some of the plants that are reopening, or maybe some of the plants that are closing. I saw that a nail factory had to close somewhere in the Midwest.
Right.
So my guess there are union issues and different things. What are some of the things that you're seeing sort of cascading through different industries that people should maybe pay attention to and maybe think about their clients?
Well, that's a really good question, Chris, because I tend to be focused on the trade issues, but there are a lot of ripple effects that we can expect. One, of course, just based on the short scenario you laid out, is that there will be a lot of bankruptcies. Another one may very well be that we could, I suppose, see a spike in M&A with either American companies being strong enough to purchase other companies, or perhaps more likely that others will purchase U.S. companies. Beyond that, I think it's a bit early. I can tell you most of what we're seeing right now is more going the other way. It's more the matter of when the 301 list 1 went into effect, the Chinese published their own list, also at 25%. But instead of then publishing a second list, what they've done is it's been subtle retaliation. And collecting that subtle retaliation is probably something that a lot of our colleagues that do corporate work will be able to pick up. So what do I mean by retaliation? For example, slow walking, as the expression goes, visa requests. Business people trying to get into China from the US, getting a visa takes longer. Getting it expedited takes longer. Slow walking inspection. So goods arrive, and it's a standard thing in every country that they get inspected. Well, the customs inspectors are now, instead of doing it on day 1, it might be day 3 or 4 or 5. I'm in California. We've started to hear stories from our Farm Belt area that sometimes the crops are being left on the pier so long that they rot. There was an interesting, you mentioned my cyber background, Chris. There was an interesting article I saw today that many of you will remember. Google left China over the censorship issue. Now they're talking about going back, but going back with a censored version of their search engine. So we're starting to see a lot of that kind of stuff go on. But in terms of how it might impact in the US, I suppose the one other area that I can think of immediately is, of course, in the tax area.
I think those are all very accurate and I would say realistic projections as to sort of the ripple effects. Sue, we really appreciate you. I know you're probably very busy these days, so to take an hour of your time to do this, I appreciate you and John coming to us a couple of weeks ago and saying that we needed to do this before the 17th. For those of you who are listening, we will send out the slides and the recording probably later today or early tomorrow, so you can share those with your colleagues or even with your clients who you think could benefit from the knowledge and insights that have been shared. So we really appreciate everybody listening today. We have a webinar later this month in August that we want to, we haven't included the slide, no worries, but we're gonna talk about GDPR again. Again, another topic that both John and Sue have a lot of interest in. We did a webinar earlier this year on GDPR, but we're gonna take a little bit of a deeper dive into it and give you some tools that might even help you as a firm, but also your clients comply with GDPR, both in a compliance standpoint before a breach, and hopefully a breach doesn't happen, but in the event of a breach, some resources and tools that you can use to comply with the various facets of the GDPR. Appreciate you joining us today, and we hope to see you soon at another webinar or one of our events. Thank you.
Chris, thanks very much for setting us all up, and
Thank you.
Thanks to everybody. Bye-bye.
Thank you.